And I will announce one more time that that we have trouble with the microphones in this room. So if you're asking a question, please make sure that the mic nearest you is on so that you will be heard, so that you can go through the live feed that is on the internet. So if you will, please. And I would let's have Representative Wilkerson give us a little invocation here. And now Representative Neal will present, and just for the record, let's give a quick overview of the resolution, and then you can introduce your guest, and we'll go right along. Thank you.
Thank you, Madam Chair, ladies and gentlemen of the committee. We talked about this a good bit at our last hearing, so I'm not going to go into a lot of detail today. To get started, I do have Jonathan Crumley with me today, who is a legal expert, and I am not. So just share with you briefly the Parental Rights Amendment that we have before us today, or a resolution rather that we have before us today, is a resolution encouraging Congress to pass a constitutional amendment that would guarantee the parents have the ultimate right in determining how their children will be raised. There is concern that if the treaty convention is the Convention on Children's Rights, is that the name of it? The UN Convention on the Rights of Children. If that treaty is ratified by the United States, because of the particularities of the United States Constitution and law, that treaty would supersede any laws that we have here in the state of Georgia relating to parental rights and children's rights, and we would certainly appreciate the opportunity to protect what has been long-held tradition of parental rights here in the state of Georgia, and that is the reason for the importance of this resolution, Madam Chair.
Does any member of the committee want to question or have any remarks for Representative Neal before we start into the debate? Okay, moving right along then. Jonathan?
Thank you for the time. I'm going to keep it very brief. We did a very detailed presentation last round, and there was some very detailed questioning on what was presented. I do want to clarify one significant matter that was left in my mind not appropriately resolved last time, and has to do with what exactly did the Troxel v. Glanville decision result in, and how has that impacted parental rights, and whether it's treated as a fundamental right or not. I would direct anybody that wants to read the opinion to read it. The point is that, yes, in multiple of the 6 opinions, there was some flowery language that identifies parental rights, the right to raise children as we see fit as parents, as a, quote, fundamental right. But that does not provide the protection that otherwise accrues and had accrued in the past to that right, because in all of those decisions and all those opinions, except for one, Justice Thomas's concurring opinion, they did not identify the test to be applied for any invasion of that right. As any constitutional lawyer can tell you, the key to whether or not a right is truly treated as a fundamental right is whether the strict scrutiny test is applied to that right. And as Justice Thomas noted in his, it was a short 2-paragraph opinion, and I'll read one sentence from it. The opinions of the plurality, which were 4 justices concurring in the opinion, Justice Kennedy, who wrote a dissenting opinion, and Justice Souter, who wrote another concurring opinion in result but not reasoning, recognize such a right. It's a fundamental right, but curiously, none of them articulates the appropriate standard of review. I would apply strict scrutiny to infringements of fundamental rights. Absent applying that test, you fall back to essentially what's known as the rational basis test. Under the rational basis test, the government pretty much wins every time. Strict scrutiny is a test that is, as a constitutional lawyer, when you have a client who had their rights infringed, you want that test applied because that requires the state to articulate a compelling government interest to infringe that right, and that the law in question is narrowly tailored to meet that end, or in some cases they say that it actually has to be the least restrictive means to address that government interest. It is a real issue. In fact, even in the state of Georgia, just after the Troxel opinion was decided, there was a Supreme Court of Georgia opinion on custodial issues and parental rights in which then Justice Hunstein wrote a concurring opinion raising the question of what test is to apply, and since strict scrutiny is not to be applied, then perhaps Georgia's longstanding tradition of requiring proof of harm or unfitness ought to be tossed out as well. So that is why this is, regardless of your position about the CRC and everything else, and whether or not you get into the minutia of the legal findings, the case law in Georgia and around the country is in a state of confusion, predominantly because the Troxel decision failed to identify in any majority opinion or any combination of the concurring opinions that strict scrutiny should be applied to any invasion of parental rights. And that's really the only issue I wanted to clear up from the last hearing.
Thank you, Madam Chair. I know we talked about this a lot last time, so I just wanted to make sure I was clear on a few points. The UN passed this resolution when? How many decades ago? Several decades ago. Okay, so we've been through, I guess, Bush, Clinton, Bush, Obama's first term, and are we concerned that, one of the presidential candidates is going to try to adopt this, or, I mean, what's the concern here? Why the need to push now?
Well, the push began several years ago. So 5 other states have already passed similar resolutions, urging resolutions for the same amendment to come out. 5 states, including Georgia, are considering it this legislative session. To me, the primary urgency is the Troxel issue that I just discussed and what standard to apply. As it relates to the CRC, the concern is that the treaty has actually already been signed. It was signed by Madeleine Albright as Secretary of State, and so now, if there are ever 67 senators in the U.S. Senate that vote to ratify it, it becomes law. And so that is a much quicker process than, as I'm sure you're aware, amending the Constitution, which provides for an amendment, but it is a very lengthy and complex process, as it should be.
Okay, so the Troxel case was 2000, so that's 12 years ago. And,
correct.
And I've got just a few more quick questions. So, so we've been through a few presidents since then, I guess. Now, my earlier question, I guess, was the example of, Christian, child, parents, not Christian. They make that decision now that, this child could not join the Fellowship of Christian Athletes, other groups. That would keep them away from experiencing their faith if their parents said, we are atheists and we demand to be, our child to be an atheist, right? Because the parents have that ultimate responsibility.
Well, I don't want to quibble theologically, but yes, physically they could, in my mind, in existing law, keep their child from attending those functions.
if we urge
but
Congress,
they can't keep the child's heart from being changed to a Christian.
And once they're 18, they can open that heart up and do what they want, because this bill would stop. But and then I guess just as a process, I guess I'm new at this. So when if we were to pass this resolution, okay,
correct,
and send it to President Obama, Vice President Biden, and Speaker Boehner, what do they do with it?
It gets added to the other list of states who have sent urging resolutions to them to show that there is support and a desire from among the states to address this issue at a constitutional level. So,
but usually, like if a constituent wants to tell me something, they will usually call me. Have we we encouraged our legislators to call Congress and tell them to do this? And is that something that would probably be maybe a little more effective than sending a piece of paper up that we may or may not agree to, that we'll debate on the floor when we should be talking about jobs, possibly? I'm just throwing it out there theoretically.
Well, I would
Okay, I guess the question is, what do they do with this piece of paper once they get it?
You'd have to ask them.
Okay.
I'm not a state
okay.
or federal representative.
Okay. And very last question, I'm sorry. I was recently in the juvenile court, family court, and some of the tough decisions they make is that the court does have to get involved if parents, have issues, drugs, and whatever the issues may be. Someone reports it. There's there's some concern out there. Does this impact at all the court's ability to work with families to make sure that if that child needs to come out of the home temporarily, that child is taken care of until that family gets those drug problems corrected or whatever those issues may be? Does this impact that at all?
It ought not to, because it's consistent with current Georgia law and Georgia approach to those situations, which again, you begin with the premise that once the state presents evidence and proves that there's some unfit component or overall unfitness of the parents, then other state interests are triggered. And I would argue that would certainly be well within the narrowly tailored interest of protecting children from the impact of unfit parents. But the question is, which comes first? Presuming the parent is fit, or presuming that the parent is unfit?
Okay. All right. Thank you.
Isn't this piece of legislation sort of a...
Yeah.
Sorry.
There you go.
Everybody can hear me now? Good, okay. Isn't this piece of legislation sort of a preemptive piece? I mean, it seems like Representative Parent stated last time that the issue is not even ripe. I mean, we're almost looking for a problem because it seems from the cases that even though it's not as clear as maybe you want it to be, we are, essentially taking this piece of paper and sending it up to Congress to alert them to something that hasn't even really been made a real issue right now. So isn't this a preemptive piece that we're doing right now if the issue isn't even right?
Again, I'm not the legal expert, but could I ask you when would be the appropriate time to get involved? Because once if this treaty is ratified, then our hands are tied and we're powerless. So it's either we're preemptive or we sit here and do nothing. And then we suffer the consequences of the treaty if it's ever ratified.
Thank you. I would like to answer a question that was asked. And yes, I have contacted my congressman and my senator, and I have asked for this to be done. And they encouraged me to see that other folks did the same thing. The problem will come when there are enough votes in the Senate from whatever side to ratify this. And at that time, you will lose control of parenting your children. You may want to do something. It may never happen to you, but there will be others that will be telling you things you can and cannot do with your child. So I would encourage you to review this. There are things in that UN charter, or whatever it's called, that would affect you. Okay. No, that's it. I just want to make a statement. Thank you.
Here. Every time I touch the thing, it goes wrong. I really am quite loud and don't need this to begin with. So I'm curious to know, are the substantive provisions of the CRC self-executing upon implementation of the treaty?
Some are, some are not.
Which are and which are not, if you don't mind me asking?
I could not tell you chapter and verse off the top of my head which ones are, but I do know Article 37, which is the primary article which directly interferes with the parent's right to discipline, would be self-executing. And also that whether or not they are self-executing or not, the treaty itself provides direct rights to children to go to court to seek to enforce provisions, whether they've been self-affected or are subject to additional changes in U.S. law.
And it's my understanding that we're the only people that have not executed this, ratified this treaty other than Somalia.
Correct.
And it is also my understanding that there is actually no movement in the U.S. Senate to ratify this treaty, and that it is 2 decades old.
That, well, as of today, I don't know, but I know that Senator Barbara Boxer has been attempting to get it on the agenda for many years, including
And it has been unsuccessful,
2008,
apparently.
2009. Correct.
Okay. So it does not appear that there is an urgent issue to me, but that's just my statement. As far as a question goes, what has happened in all of the countries other than Somalia that are members of the UN that, I mean, are people in Britain and France and all these other countries up in arms, nervous about their ability to now rear their children? I have failed to catch the onslaught of public news about this problem. So please enlighten me.
Sure, be glad to. What is incorporated into the CRC is a radical redefinition of how rights are viewed in America in some regards. It essentially incorporates, just like any other human rights document coming out of the UN, there's 5 areas or bundles of rights that are addressed: civil rights, political rights, economic, social, and cultural. Of those 5 bundles of rights, 2 are addressed in a similar fashion to us, meaning they're negative rights, things that the government ought not to be able to do. The other 3, though, are deemed positive rights, meaning these are obligations and duties of the signatory countries to provide for by whatever means appropriate. Subject to, through and including, there are provisions and clear statements from the committee that oversees the implementation of the treaty in Geneva, that if a nation's overall defense spending outweighs its spending towards child services, it is obligated to reduce defense spending and increase spending to child services. In other words, we would be ceding authority to Geneva to make those kind of fundamental decisions.
Is that a self-executing provision?
Let's try to keep it so we...
The other point is none of those other countries treat treaties the way our Constitution treats treaties. For example, every Muslim nation that has signed this treaty, within their laws, they make the exception that any part of the treaty that violates Sharia law will be not enforced in the Muslim nation. We don't have a comparable provision. In fact, we have the opposite provision in Article 6 of our Constitution. And in addition to the CRC, which I know you are intimately focused on, don't forget, we do have ambiguity and we do have problems in U.S. law because of what the Supreme Court did in Troxel. Again, no recognition that parental rights, which are described as fundamental rights, are subject to the strict scrutiny test. And Georgia even has one Supreme Court justice that uses Troxel to try to chip away at the way our state has viewed parental rights for the history of the state. I can cite to you cases around the country where application of the meaning and intent of the CRC and the ambiguity from Troxel has resulted in all kinds of invasions of parental rights throughout the nation, including things like denying medical records of children to parents.
But my question was about other countries, and we can move on because I know I'm not the only person who has questions, but that's not really. Thank you. I appreciate that. Yes. Thank you.
What's the legal procedure or the procedure in the Senate should they, since they have not ratified this, and is there some type of action the U.S. Senate could take to refuse to ratify this? And what's that process in the U.S. Senate?
It's been signed. The treaty is, we are a signatory to the treaty. Madeleine Albright, as Secretary of State under the Clinton administration, signed it, but we have not adopted or ratified it, so it's not legally binding on the United States. Once a president submits it to the Senate for ratification, all it takes is a 2/3 majority vote of the then sitting senators in favor of the treaty to become a binding treaty in the United States. And
there's no other process, constitutional provision that says the U.S. Senate can tell the President and the Secretary of State that this is not wanted here in the United States. Send it back.
There would have to be a vote of more than 1/3 of the senators to not ratify the treaty to stop that from happening.
All right. Thank you.
Are there other questions?
With respect to the Troxel v. Granville case, let me back up. What I find difficult about this issue is I don't get it in terms of the need for it. I think all of us agree with what this wants to do, which is to ensure that parental rights are protected. What I'm really finding challenging is to find that this is a crisis in America. And candidly, if I thought that it was, I wouldn't care if this was sponsored by the Tea Party or which organization. I would be 100% with you. But I am having a sincere difficulty identifying where the issue is. And to that end, in the Troxel case, you've made an issue this time. Last time, you were unable to identify anything within the case that the committee should consider. This time, you brought forward the strict scrutiny issue. And the question is that is it not true that the court found in Troxel in support of the parents, even without applying the strict scrutiny standard that you've identified? And is it further not true that, to keep reading in the part that you quoted from Justice Thomas's opinion, that he said that he would have still found in favor of the parents even under the rational basis test?
I don't read anywhere in Thomas's concurring opinion where he addresses the rational basis. He does say that he would apply the strict scrutiny test and that they lack the legitimate governmental interest, to say nothing of the compelling one, in second-guessing a fit parent's decision regarding visitation with third parties. On this basis, I would affirm the judgment below. I guess if you're referring to that as the rational basis test, then yes, it's possible that a majority of Supreme Court justices would look at something similar to the Washington statute and rule in favor of parental rights. The question, though, is, as legislators, do you believe this is a fundamental right? Do you believe, regardless of what party or political persuasion is in power, that the government ought to be handicapped unless and until they show a parent is unfit? Then I would say vote in favor of it, regardless of who's sponsoring it, and regardless of whether you think there's an imminent danger or threat to you and your family. I can assure you, if you do the research for the cases around the country, there are case after case after case of parents who are fit, normal, average, good parents that for one reason or another have their children taken from them, have their ability to care for their children and provide for their children in the way they see fit, hampered and restricted because of overzealousness on the parts of certain government agencies. That is a fact. And I would urge you to do the research and then look at it in terms of the fundamental policy rationale. Do you believe that is a fundamental right, that fit parents ought to be able to raise their children? If you do, I don't see how you could oppose this language, because all this does is ask the federal Congress to enshrine that fundamental right and apply strict scrutiny to that fundamental right from this day forward.
Madam Chair, one follow-up, please. And I appreciate that, and I assure you that I have done the research, but I'd also be open to reading whatever cases you'd like to cite for me. With respect to the proposed constitutional amendment itself, and I think this is important because this would be what we would be recommending be enacted, the question that I have is Section 1, which, for those that want to follow, is on line 37. The liberty of parents to direct the upbringing and education of their children is a fundamental right. What would happen if a parent were, if this were brought into law, say that they didn't want a certain subject being taught in a public school, or take some other activity? I think Representative Wilkerson made a statement to the effect of didn't want maybe a religious affiliated organization on school. How would you foresee that playing out? Would that mean that the parents would be able to trump local school boards in terms of how decisions about education were implemented? Can you give us some guidance into how this would be applied?
I would suspect that existing law in that area would apply, and there are numerous federal cases that predate Troxel that essentially come to the conclusion that the right to educate a child it doesn't require you to use the public school system, but once you as a parent elect to use the public school system, you have voluntarily limited those rights. No right in the Constitution, even a fundamental right, is not an absolute right. Okay, all rights are limited. And once a parent makes the educated and free decision to avail themselves of a state school, a public school, then those rights become, by that decision, limited.
If I could have one follow-up, ma'am, because I'm not sure that I understand. If what you said is that we would apply existing law to determine that question, why would we need this? Did I miss something?
Said before Troxel, case law that predates Troxel.
So what would this do?
Okay, well, Troxel changed the standard that was applied to parental rights by refusing to acknowledge that it was subject to the strict scrutiny test. Before Troxel,
is that what
strict scrutiny was applied.
I disagree. That's what the court did.
Well,
but
I don't know which y'all is right, but whichever one. Okay, I'm gonna give you one more shot at the. One more, Scotty. You got an extra.
Thank you, Madam Chair. I do appreciate that.
You want a break, and I'll go to Representative Pruitt next.
Yes, ma'am. Let's do it. Thank you.
Chair, thank you so much. You've obviously a very patient person. As I listen to this discussion, I think what I'm hearing is, and I may be wrong, is that I don't think anybody really disagrees with what this does or what it says. It sounds like to me we're more of an argument about if it's necessary or not. Well, my question to you would be, is it not true that wouldn't it be better to be preventative in a situation like this when we actually have this looming over our heads to just go ahead and vote it through? It is not a law, but it basically puts us on record that this is how we feel, and if this is how we all feel, which I'm assuming that we do from what I've heard, we're not arguing the language that we ought to just vote this thing through and I can go home.
Very good, Mr. Chair. I got a couple more people that want to weigh into this. Well,
Let me see. I was teetering after that speech, but I figured I had my hand up in the chair as being so patient. But two quick questions. You had mentioned that there was cases out there where, and I'm an example kind of person, so it helps me understand. Can you give me an example where a parent's rights have been pulled away or the child's been pulled away when it really shouldn't have, that we need to make sure we fix?
Yeah, I off the top of my head, I know there's a case in Michigan that's in the middle of litigation where parents chose to refuse some recommended treatment and go with alternative treatment, and their child was taken away from them because of that decision. There's a case out of Washington State that I don't believe I can cite to you to a record because it's a juvenile action in which a judge or a child petitioned the court to not go to church 3 times a week. Wanted to go to church Sunday morning, not Sunday morning, Sunday night, Wednesday night. And the judge said, you're right, 1 day a week for 13-year-olds good enough for me. It should be good enough for the parents. Either you agree to 1 day a week church or I take the kid from you. There's a case in California.
That was where? I'm sorry, that was where?
Washington, the state of Washington.
Now, with this treaty, wait a sec, I got a question. I'm curious. So this treaty hasn't even taken effect, and we're already running over rights of parents, you're saying. So will us signing this constitutional amendment then give the power for this, parents to refuse treatment to their child if they have cancer? Is that what you're saying? I mean, I just want to make sure that if we want to make sure they have that ability to refuse treatment, that we give them that ability, and will this treaty do that?
The CRC?
No, not, I mean the constitutional amendment. Basically, what you're quoting is already happening before we have signed onto this treaty that nobody thinks we will sign on to necessarily.
Right.
But if we did sign onto the treaty, we're already doing these things that you're concerned about. I mean, if we want to make sure that our child doesn't get treatment for cancer, you want to make sure that this constitutional amendment allows us to do that. And I just want to make sure I'm kind of going down the right area because you referenced this case.
Number one, you made it's not a refusal to get treatment for cancer. It was an alternative treatment. Not a refusal to provide medical treatment, but a decision by the parent that I don't want what this doctor recommends, I want what another doctor recommends.
I thought it was more healing.
You may be talking about different
Yeah, was the question, what was that alternative form of treatment that that parent was denied?
But the point is, this makes my point, that the policy decision is, do you think a fit parent ought to have their constitutional rights protected under strict scrutiny or not? If you don't, vote against this resolution. If you do, vote for the resolution. If you don't think it's an urgent crisis and it's a waste of everybody's time, then vote against it for that reason. But the point is, the policy decision, which y'all are vested with making, is, do you think this is a fundamental right entitled to strict scrutiny treatment or not?
Would you agree that the Troxel decision, regardless of standard applied, found in favor of the parents?
Yes, that's what the ultimate holding was.
Thank you.
Thank you. Thank you so much. Thank you so much, Madam Chairman. I actually, if y'all may recall, last time we met on this issue, I was doing a follow-up, and that's when we tabled it. So actually, I want to ask that last question, if you don't mind, and I appreciate your indulgence. Your mention of the case, and I do recall reading about it in the media, where there was a lot of controversy about parents not going with accepted medical treatment for their child's cancer. I do recall that case. So the question actually that I was asking you last time, that now you've reminded me of, and I would love to hear your thoughts on it, is I have read that there is some concern that this could make it harder to remove children in cases of legitimate abuse. And I guess when you talk about something like this kid had cancer, and basically it ended up that the court was saying these parents are standing in the way of what could save his life. They just are. And so now that reminds me, hey, what about all these things that I read that said this could make it more difficult in cases of legitimate abuse or bad situations to get a child out of that situation?
No, I don't think it would at all, because it recognizes the current state of Georgia law in the way it is approached, which is the state has to prove parents are harming the child or are unfit.
And that didn't happen in that other case? Or did it?
No, I don't know enough of the details of what the decision was, but
I think it did. Okay. Thank you.
Burning questions now. Representative Brockway. All right. All in favor say aye. Aye. All opposed say no. No. Okay, let's make our let's make our hands go. Okay, all those in favor raise your hand. Okay, all those opposed? Just one hand will do. Preferably you're right. The vote was 10-5, so the motion do pass for H.R. 738. And thank you very much for your patience and for your testimony.
Thank you, Madam Chair.
And ladies and gentlemen, I believe this will be the last meeting of this session, so I've enjoyed having each and every one of you on the committee and look forward to perhaps you're being on it next year. Thanks.